If you file a patent with the patent office, then your application is assigned to a patent examiner. If you file a trademark application, then your application is assigned to a trademark examiner. Now, the chief difference between filing a patent application versus filing a trademark in terms of the examiners is that trademark examiners are all licensed attorneys. Patent examiners, on the other hand, are not necessarily licensed attorneys. So let's talk first about patent examiners. So the patent office is divided up into art units, okay? The art units indicate essentially a grouping. So a certain class of cases will go to certain art units. Now, you can see why that makes sense, right? Because you want people that specialize and focus in a certain technical field, in a certain subject matter area, so that they can be more efficient at examining cases. You have patent examiners, and they're part of art units, and the patent examiners themselves, as I said before, may or may not be licensed patent attorneys. Typically, in our experience, they usually are not licensed attorneys, but they do have technical degrees, and they have sat for the patent bar. We haven't talked about the patent bar in our show yet, but the patent bar is essentially the licensure required to practice before the patent office. So by taking the patent bar and passing it, you're granted your registration number that allows you to represent inventors before the patent office. Now, examiners must also take this exam. They're obviously not going to be representing people before the patent office, but that's the base requirement for being an examiner. To even sit for the patent bar, you have to have a technical degree. For example, you need to have a BS, say in chemistry, in engineering. You need to have a technical bachelor's degree. Now, there's other ways to actually become a licensed agent and sit for the patent bar, but suffice it to say that if you take the patent bar and you're not an attorney, then you're called what's called a patent agent. If you take the patent bar exam and pass, and you are already an attorney in any jurisdiction, say you're licensed in California, then at that point you are then lawfully a patent attorney. Going back to examiners, the patent examiners may or may not be patent attorneys, which means that they've definitely passed the patent agent exam, but they may or may not be attorneys, and so they may just be patent agents. Now, when you file a patent application, your patent app is going to be assigned to an examiner in a specific art unit, depending, of course, on the subject matter of your patent application. And that can take several months to even over a year. It really just depends. Some art units are busier than others and have greater backlog, and so being assigned to an examiner will occur at different rates of time depending on what art unit and the subject matter of your application. Now, it's only until you're assigned an examiner that your patent application will be examined, okay? After you file your patent application, you're essentially waiting for examination. You're waiting for your application to be assigned to an examiner. Only after is it assigned to an examiner will your application then trigger certain deadlines internal to the examiner's docketing system. So they have to satisfy certain deadlines after they're assigned a case. In the case of filing a non-provisional patent application, your application will be assigned a serial number, which is going to be used to identify the application throughout the entire process. And the filing receipt, if you file electronically, is actually granted immediately. It's granted right away. You're given a serial number, and you can use that serial number to track your application through what's called PAIR. This PAIR is the electronic system used by the patent office to keep track of all the records. So after you file your patent application, a filing receipt should issue in 2 to 3 weeks. Now, that is only the case if you satisfy all the requirements to obtain a filing receipt. So it's very important, for example, that you make sure that after you file your patent application that you don't receive what's called, for example, a notice of missing parts or any other correspondence that requires you as the applicant or the inventor to act or respond to a notice. Now, what's the danger? Let's say that you receive a notice, say for example, that you receive a notice to correct the drawings. If you fail to respond, then your application will go abandoned. Another common error that people might make is they may not submit the correct fee amount. Let's say they submit extra claims but don't pay for them, then they're going to receive what's called a notice of missing parts, requiring them to make up and pay the extra fee amount. But if, for example, you forget to pay the extra fee and you forget to respond to the notice, then your application will go abandoned. And then you're going to have to find yourself in the situation where you're filing a petition to revive, and they're very, very expensive. It's also very important to make sure that you have a filing receipt, because the filing receipt indicates, okay, you've been granted a filing date, you're in the queue, now we just have to wait to receive what's called an action on the merits, or also just an office action. Trademark applications are also similar in that after filing a trademark application, you immediately get a filing receipt that indicates the filing date. Now, the trademark office is much, much faster than the patent office, and so your application is going to be assigned to a trademark examiner typically within 3 to 8 months. Now, our experience has been that trademark applications are typically assigned to an examiner after about 3 months, and sometimes quicker. Now, again, these are all general statements, right? Sometimes things happen more quickly and sometimes things happen more slowly. But for trademark applications, once you file electronically, you're also granted a serial number. And then after that point, you're just waiting for your application to be assigned to an examiner to undergo the trademark examination process.